In this section, we will learn about safeguards for mandated reporting in California, caretaker absence and incapacity, interviewing children at school, intaker-screener scenarios, child welfare investigations, temporary custody, and red flags for abuse in childcare settings. The first thing you should know is that your identity as a reporting party is confidential and will only be given to the agencies that investigate mandated reports. The second thing is that mandated reporters who report a known or suspected instance of child abuse or neglect, as required by law, shall not be civilly or criminally liable for any child abuse report unless it can be proven that the reporter knowingly made a false report. Finally, mandated reporters cannot be prevented from reporting nor lose their job for making a report. Reporting duties are individual, and no supervisor or administrator may impede or inhibit the reporting duties. No person making a report shall be subject to any sanctions for making the report. However, internal procedures to facilitate reporting and apprise supervisors and administrators of reports may be established provided that they are not inconsistent with the reporting laws. So report anything that you suspect, because it is better to be wrong about instances of child abuse than leave a child helpless in a violent or neglectful situation. No one can prevent you from reporting abuse or neglect. As a mandated reporter, you cannot delegate this to someone else to do. And the name of the reporter remains confidential. Therefore, you do not have to be in fear of retaliation from anyone. A volunteer assistant in your daycare tells you that a child has told her details of sexual abuse by her father, who lives in the home. What are you obligated to do? The answer is C. Report to a child protection agency and the licensing office. While volunteers who work with children are encouraged to report concerns of abuse or neglect, they are not mandated reporters. You must be the one to make the report. It may be also helpful to ask the volunteer to assist you in providing information while making the report. You do not need to interview the child, as the disclosure by the child to the volunteer meets the criteria for reasonable suspicion. Also, you should not interview the child about the abuse unless you are trained to do so. Finally, calling the child's mother could interfere with the investigation and possibly create a risk to the child. Caretaker absence and/or incapacity is when a caretaker or parent reaches a point where they are not capable of taking care of a child. Law enforcement is usually involved at this point. While helping a child out in your facility change his shirt, you notice that his back is bruised and scabbed and the injuries appear patterned. When you ask him what happened, he looks uncomfortable and says he fell. He is avoidant and unwilling to give you more information about how the injury occurred. When you talk with your supervisor about your concerns, she says that she knows the family and there is no need to make a child abuse report. What should you do? The answer is B. Report to a child protection agency and to the licensing office. This is the correct answer. A child abuse report should be made based on the type and location of the injuries and the lack of reasonable explanation. As a mandated reporter, you are responsible making sure that this report is made. A representative from a child protective agency may deem it necessary to interview the child at school. Again, you should never be the person doing the interview. Only someone from the child protective agency or law enforcement should interview the child. Under the Family Educational Rights and Privacy Act, FERPA, schools can release the information to the investigating agency without parental consent in cases of health and safety emergencies. When you call in for possible abuse or neglect, an intake screener will do one of the following: assign the case to a worker requiring an immediate response, assign the case to a worker requiring a 10-day response, screen the case out with full documentation. This decision is decided by the intake screener at the agency. While doing a child welfare investigation, the emergency response worker may substantiate abuse or neglect, make an inconclusive finding, or determine the report was unfounded. All substantiated and inconclusive reports must be reported by the Child Protective Agency to the Child Abuse Central Index, CACI. The information obtained by the CACI is available to aid law enforcement, investigations, prosecutions, and to provide notification of new child abuse investigation reports involving the same suspects and/or victims. Information is also provided to designate social welfare agencies to help screen applicants for licensing or employment in child care facilities and foster homes, and to aid in background checks for other possible child placements and adoptions. So the information they receive is key to making sure the wrong people are not around children. If a social worker finds immediate danger or immediate need for medical care, they may take custody of the child. This is when law enforcement gets involved, and it would fall under WIC 305 and 306, which gives them the authority to take custody of the child without a warrant. Although there are many protections in place to ensure the safety of children in the child care setting, it is important to be aware that abuse and neglect in daycare settings does occur, and accounts for up to 3% of all confirmed cases in a given year. Child care professionals should be educated about child development in order to establish age-appropriate expectations and discipline. Child care professionals are never to use corporal punishment. The California Code of Regulations, Title 22, provides that children at licensed care centers have personal rights that include freedom from corporal or unusual punishment. Supervisors who witness inappropriate behaviors by child care staff should document observations and should meet with the staff member to address their concerns and establish a performance improvement plan. Termination of the staff member may be necessary if behavior that is detrimental to the children does not improve. Note, if the behavior falls within the legal definition of child abuse, it must be reported. As a child care provider, you and other staff members are responsible for the well-being and safety of the children in your care. If you become aware that a colleague has done something that could be considered abusive or neglectful, you are required to report your suspicions. As in other situations of suspected abuse or neglect, a disclosure by the child should always be reported so that the proper authorities can investigate the situation to determine the credibility of the allegations and identify additional victims. It is not appropriate, nor is it within the training or expertise of child care staff or supervisors to investigate allegations of abuse prior to making the report. Penalties for failure to report apply to all situations of child maltreatment, regardless of the identity of the suspected perpetrator. Remember that reports of suspected abuse in the child care setting must be made by both your local child care protection agency and to your local licensing office. You are the director of a child care facility. The parent of one of the children in your program contacts you because she is concerned about the behavior of Paul, a college student who volunteered in your program. She says that her son told her that Paul frequently had him sit on his lap and Paul rubbed his thighs. She tells you that her son said this made him feel uncomfortable and that he tried to refuse, but Paul insisted and sometimes offered to bring him a special treat for the next day. What should you do? The answer is A. Make a suspected child abuse report. The child's discomfort regarding Paul's behavior and the suggested persuasion involved should alert you to possible abuse. In addition, making a report will give the investigators the opportunity to explore the allegations and to identify other possible victims. If the person suspected of or known to have abused a child is a colleague or supervisor of the mandated reporter, the report cannot be made anonymously. Your identity as the reporting party is confidential and will be only given to those agencies that investigate mandated reports.